We continue to follow breaking news in that civil court case against former President Donald Trump. The judge, Arthur Engoron, has imposed a penalty of more than $350 million against both the former president as well as his adult sons and his corporation. That case brought by New York Attorney General Letitia James. The former president has been ordered now to pay more than $354 million in damages. It's believed that he needs to pay that amount in the next 30 days. His co-defendants are being ordered to pay another $10 million in fines. Meanwhile, the judge also imposed other penalties banning the former president from conducting business in the state of New York over the next 3 years. And his sons, Eric Trump and Donald Trump Jr., are prevented from serving as an officer or director of any New York corporation for the next 2 years. Now, as we've reported, that sum, north of $350 million, will need to be paid by the former president. And both Eric and Donald Trump Jr. have each been ordered to pay a little bit more than $4 million each. We also want to tell you about former Trump Organization CFO Alan Weisselberg. He's been ordered to pay $1 million. CBS News legal analyst Ricky Cleenan joins us now. Ricky, always good to talk to you. So I want to get your take on this question I've been pondering. What do you think is the bigger penalty that's more impactful to the former president? This $354 million judgment against him, or these other bans, the inability to conduct business in New York for the next 3 years, the inability to even secure loans from any institution that is based here in New York?
I think the injunctive relief, which is what you are referring to, the inability to be an officer or director, the inability to do business within the state of New York, in the end.
Friends, thank you for being here today. In an era where the 24-hour news cycle often prioritizes velocity over veracity, and where headlines are crafted more to incite emotion than to inform the electorate, it becomes increasingly difficult to discern the signal from the noise. We are inundated with phrases like game over, the end of the line, and the ever-popular fatal blow. Yet, as those of us who have witnessed decades of American political history understand, reality is rarely as binary as a cable news chyron would have us believe. Today, I want to invite you to step back from the sensationalism and join me in a forensic examination of the recent legal judgments against Donald Trump. We are going to look at the ledger, the assets and liabilities, the rulings and the appeals, to answer a fundamental question. Do these recent court decisions truly represent a fatal blow to his presidency and power, or are we witnessing something far more complex? To get to the bottom of this, we need to look specifically at the recent breaking news regarding the civil fraud case in New York, and then place that side by side with a series of federal rulings concerning executive power. The narrative being pushed right now is one of total collapse. But if we look closer, the reality is a picture of significant, painful constraint, but not necessarily the political termination that some are predicting. I want to start right at the center of the storm by addressing the massive financial judgment handed down by Judge Arthur Engoron, because this is the story dominating every screen in the country. By now, many of you have seen the numbers in that civil court case brought by New York Attorney General Letitia James, and they are soberingly large, even for a figure of Donald Trump's wealthy stature. Judge Engoron has imposed a penalty of more than $355 million against the former president. When we include his adult sons and the Trump Organization, the scope of this financial penalty widens even further. This is not a theoretical loss. This is a mandate for hard cash. The court has ordered that this amount, which constitutes disgorgement of ill-gotten gains, is believed to be payable within 30 days. Now, for those of us who understand business, we know that net worth and liquidity are two very different things. A real estate empire is often asset rich but cash poor. To be ordered to pay over $350 million in damages is a liquidity crisis of the highest order. It forces difficult decisions, the potential liquidation of prized assets, the restructuring of debt, or the scramble to secure a bond in a financial market that may be wary of the risk. But here is the thing, to focus solely on the dollar amount is to miss the forest for the trees. The financial penalty, while devastating in the common parlance, is perhaps less significant than the operational handcuffs Judge Engoron has placed upon the Trump family. The ruling bans Donald Trump from conducting business in the state of New York for the next 3 years. It similarly prevents his sons, Eric Trump and Donald Trump Jr., from serving as officers or directors of any New York corporation for 2 years. I want you to really consider what this means in practice. New York is not merely a state in the Union. For the Trump Organization, it is the nervous system. It is the headquarters, the home of the brand, and the jurisdiction under which many of his entities are incorporated. To be barred from the boardroom in one's own home state is a form of corporate exile. Furthermore, the judge has blocked the organization from applying for loans from any financial institution chartered in or registered with the New York Department of Financial Services for 3 years. In the world of high-stakes real estate, debt is oxygen. By cutting off access to New York banks, the court has effectively placed a tourniquet on the company's ability to breathe, expand, or even refinance existing obligations. I want to pause here and hear from you on this specific point. Do you believe this penalty, specifically the ban on doing business in New York, fits the finding of inflating assets? Or do you see this as a selective application of the law designed to cripple a political opponent? Let me know your thoughts in the comments below. Now, to understand why the penalty was this severe, we have to look at the judge's specific rationale. In his February 2024 ruling, Judge Engoron did not mince words. He described the conduct of the defendants as shocking the conscience. This is a specific legal standard, implying that the fraud was not merely a clerical error or a difference of opinion on valuation, but a systemic intentional deception that violates the basic norms of equity and fairness. The court found that the Trump Organization engaged in persistent fraud by systematically inflating asset values. They claimed properties like Mar-a-Lago, the Trump Tower penthouse, and various golf courses were worth far more than their actual market value. Why? To obtain favorable loan terms and lower insurance rates. Conversely, when it came time to pay taxes, values were often minimized. This arbitrage of truth, telling the bank one thing and the taxman another, is what the court found so egregious. Judge Engoron noted a complete lack of contrition from the defendants, suggesting that without strict oversight, the behavior would likely continue. And this brings us to perhaps the most intrusive part of the entire ruling, the installation of an independent compliance monitor. This is not a mere formality. For a man who has spent his entire career operating a private company with absolute autonomy, having a court-appointed watchdog looking over every transaction, every ledger entry, and every business decision is a profound loss of control. It is a humiliation for a business leader who prides himself on being the ultimate decision-maker. The monitor ensures transparency, yes, but it also ensures that the Trump Organization can no longer operate in the shadows or on the fringes of standard accounting practices. So when we ask if this is a fatal blow, we have to ask ourselves, fatal to what? Is it fatal to Trump, the businessman? Quite possibly. The combination of the fine, the ban on leadership, the restriction on lending, and the imposition of a monitor creates an existential threat to the Trump Organization as we have known it. It attacks the very foundation of his identity as a self-made, successful tycoon. It contradicts the narrative he has built his career and arguably his political persona upon. Now, we have to be careful here not to conflate the businessman with the politician. While these penalties are a serious blow to his personal finances and his corporate brand, they do not inherently strip him of his political power. They do not remove him from the ballot. They do not constitutionally bar him from the presidency. A man can be bankrupt and still be president of the United States. The Constitution lists qualifications for office, age, citizenship, residency, but it does not list solvency or a clean civil liability record. That is why, while the fatal blow rhetoric captures the severity of the financial wound, it overstates the political lethality. He remains in the arena. He continues to fight. This distinction is crucial, but I'm curious. Do you think the average voter separates Trump the businessman from Trump the politician? Or are they one and the same in your eyes? Drop a comment and tell me how you see it. But the financial fraud case is not the only front in this legal war. If we broaden our aperture, we see that Trump is facing significant setbacks in the policy realm as well. Defeats that strike closer to his ability to govern and wield executive power. To get the full picture, We need to look beyond New York and examine the recent federal ruling from January 2026 regarding his executive order on elections. Trump has long made election administration a centerpiece of his platform, frequently criticizing vote-by-mail systems. In an attempt to reshape this landscape, he issued an executive order targeting states that utilize these voting methods, seeking to pressure or punish them, potentially by withholding federal funds or creating other administrative burdens. But here is what happened. A federal judge blocked the majority of this order. The legal reasoning here rests on the bedrock of federalism. Under our Constitution, the administration of elections is primarily the province of the states. The Times, Places, and Manner Clause gives state legislatures broad authority. By attempting to use the federal executive branch to strong-arm states into changing their election procedures, the court found that Trump exceeded his presidential authority. This matters because it is a significant defeat for his agenda. It neutralizes a tool he attempted to create. It signals that the judiciary is willing to act as a check on executive overreach, specifically when it infringes upon the rights of the states. For a voter base that often values states' rights, this ruling is ironically a defense of that very principle, even if it blocks the preferred policy of the leader. We see a similar pattern playing out in the energy sector. The Trump administration attempted to halt the Revolution Wind Project, a multi-billion-dollar renewable energy development off the coast of Rhode Island. This action was consistent with his vocal opposition to offshore wind farms. However, a federal judge ruled that this stoppage was unlawful. The court found that the administration had either failed to follow proper administrative procedures, ignored statutory requirements, or acted in a manner that was arbitrary and capricious. The result was that the project was allowed to resume. Again, the lesson here is one of constraint. The president has immense power, but he is not a king. He cannot simply wave a hand and stop a legally permitted infrastructure project because he dislikes the technology. He must operate within the confines of administrative law. These rulings on elections and energy are fatal to those specific policy initiatives. They kill the executive order. They kill the stoppage. But do they kill the presidency? No. They merely define its boundaries. Now, if we were to stop our analysis right here, the picture would be undeniably grim for the former president. Financial devastation, business exile, and policy blockades. This is the narrative preferred by the fatal blow commentators. But as independent thinkers, we have to look at the entire board, not just the pieces that are falling. We must look at where Trump has found success in the courts, because these victories complicate the fatal narrative significantly. For instance, we absolutely cannot ignore the Supreme Court's 2024 immunity decision. This was a watershed moment in American constitutional law. The court ruled that presidents enjoy absolute immunity for conduct within their exclusive sphere of constitutional authority and presumptive immunity for other official acts. Think of this ruling as a powerful shield. While it does not help him in the civil fraud case we discussed earlier, because inflating assets on a bank loan is a private business act, not a presidential duty, it is immensely valuable in the realm of criminal law. It creates a high barrier for prosecutors attempting to charge him for actions taken while he was in the White House. It forces courts to parse every allegation to determine if it was an official act. This process takes time, years in fact, and often results in charges being whittled down or dismissed entirely. The immunity ruling effectively inoculates him against certain types of fatal blows that could come from the criminal justice system. It ensures that while his wallet may be drained by civil courts, his liberty is protected by the Supreme Court's interpretation of executive privilege. I know this is a polarizing topic. Do you agree with the Supreme Court that presidents need this level of immunity to function, or do you believe it places them dangerously above the law? I'd value your perspective on this. So, bringing all of these threads together, the civil fraud judgment, the policy injunctions, and the immunity protection, what is the real assessment? I believe the phrase fatal blow is a linguistic trap. Fatal implies an ending. It suggests a termination of viability. If a blow is fatal, the fight is over. Yet, as we watch the news today, the fight is clearly not over. Donald Trump continues to hold rallies. He continues to issue statements. He continues to command the loyalty of a significant portion of the electorate. A more accurate assessment, one that respects the intelligence of history, is that Trump is suffering from death by 1,000 cuts, or perhaps more precisely, containment by 1,000 rulings. The $355 million judgment does not end his career, but it severely stresses his resources. It forces him to divert time, energy, and capital away from politics and toward legal defense and solvency. The monitoring of his business humiliates him and restricts his freedom of movement in the marketplace. The policy blocks prevent him from unilaterally enacting his will, forcing him to find other, harder paths to his goals. These are constraints. They are weights in the saddlebag of a racehorse. They slow him down. They make the race harder. They damage his standing with independents who may be weary of the constant chaos and corruption findings. But they are not a guillotine. The fatal blow framing is seductive because it offers a sense of closure. It promises that a single judge with the bang of a gavel has resolved the tumultuous era of Trump. But the American legal system rarely works that way. It is a grinding, iterative process. The New York fraud judgment will be appealed. Trump's lawyers will argue that the valuation of real estate is subjective, that the banks lost no money, a common defense he employs, and that the penalty is excessive under the Eighth Amendment. That appeal will wind its way through the appellate division and possibly to the New York Court of Appeals. That process alone could take years. Similarly, the federal policy rulings will face scrutiny. The definition of official acts under the immunity ruling will be litigated case by case. The story is not finished. It is merely in a new, more intense chapter. For us, as observers who value wisdom over reaction, this distinction matters. If we believe the fatal blow hype, we may become complacent, thinking the situation is resolved. If we ignore the rulings entirely, dismissing them as fake news, we detach ourselves from the reality that the rule of law is indeed holding a powerful man accountable in concrete, verifiable ways. The truth lies in the middle. The legal system is working. It is producing a mixed bag of results. As it often does in complex cases involving unprecedented circumstances, it is punishing fraud. It is checking executive overreach, but it is also protecting constitutional privileges. Let's talk about the why behind the video title, Trump Loses It as Judge Delivers Fatal Blow. The loses it portion usually refers to a loss of emotional control or a frantic reaction. But in our analysis, the true loss is not one of temper, but of agency. For a man like Donald Trump, whose entire life has been defined by the projection of strength and the exercise of unilateral will, the loss of agency is perhaps more painful than the loss of money. To be told by a judge, you cannot do business here, you cannot serve as a director, you cannot hide your books, you cannot stop this wind farm, you cannot pressure this state. This is a systematic stripping away of his power to act. The judge in the fraud case, Judge Engoron, noted that the defendants were likely to continue their behavior without strict oversight. This is a damning character assessment. It suggests that the court views the former president not as a trustworthy actor who made a mistake, but as a recalcitrant operator who requires a chaperone. That is the fatal blow to the reputation. It recasts the master of the deal as a liability that must be managed. Furthermore, we must consider the cumulative psychological toll. We are discussing a man in his late 70s. The energy required to fight a multi-front legal war, civil fraud in New York, defamation cases, federal election interference cases, state election cases, is immense. The fatal blow might not be a single legal ruling, but the aggregate weight of this pressure on a human being and a political organization. Resources are finite. Every dollar spent on legal fees is a dollar not spent on advertising. Every day spent in a deposition is a day not spent in a swing state. Yet, we see the resilience. We see the counter-narrative being built, that he is a martyr, a victim of a weaponized justice system. For his core supporters, these fatal blows are merely evidence of the deep state attacking their champion. In this way, the legal defeats are alchemized into political fuel. This is why the fatal terminology is so misleading. In the physics of conventional politics, a fraud conviction is a death sentence. In the physics of Trumpian politics, it can be a rallying cry. However, facts are stubborn things. Regardless of the political spin, the financial reality remains. The $355 million must be addressed. The interest on that judgment ticks up every single day. The monitor is in the building. The banks are reading the verdict. These are hard realities that no amount of rallying can wish away. Now, I want to take a moment to really drill down into the specific mechanics of what happens next, because the devil, as they say, is in the details. We often hear, "he will appeal," as if that is a magic wand that pauses everything and makes the problem disappear. But in the cold, hard world of New York's legal system, it is not that simple. To even begin an appeal that stays the enforcement of the judgment, meaning to stop the state from seizing his assets while the court reviews the case, Trump generally has to post a bond. This isn't just a signature on a piece of paper. It usually requires putting up the entire amount of the judgment, plus interest, or at least a very significant percentage of it, into an escrow account or finding a surety company to back it. Think about the liquidity squeeze we discussed earlier. We are talking about needing access to nearly $500 million in liquid capital, or finding an insurer willing to take the risk on that amount for a fee. If his assets are primarily in real estate, he can't exactly deposit a skyscraper at the courthouse clerk's window. This creates a fire sale risk. If he needs cash fast to save his business empire from immediate seizure, he might be forced to sell assets at a discount. That is the hidden fatal blow, not the judgment itself, but the desperate economics of the appeal process that could erode his wealth far faster than the legal arguments can save it. Furthermore, we have to look at the opportunity cost, a concept I know you are all familiar with. Every dollar spent on these bonds, on these armies of lawyers, and on these compliance monitors is a dollar that is not being spent on the 2024 campaign. While super PACs have been footing many of his legal bills, there are limits. There is a burn rate to legal defense that can outpace even the most robust fundraising. We are seeing a collision between the legal calendar and the political calendar. Money that should be going to get out the vote operations, data analytics, and advertising in swing states like Pennsylvania and Michigan is being diverted to legal survival. In a general election where margins are razor thin, the lack of financial firepower for the ground game can be decisive. The fatal blow might not come from a judge's gavel, but from the quiet attrition of resources that leaves the political machine underfunded at the critical moment. While the headlines scream about Trump losing it in court, the real loss might be occurring in the campaign's bank account, slowly bleeding the organization of the resources it needs to compete against a well-funded incumbent. This is the unglamorous, logistical reality that the dramatic, fatal blow narratives completely miss. It is a war of attrition. And in a war of attrition, he who runs out of supplies first loses, regardless of how loud they shout. It's a simple question of math, really. Do you think Trump's loyal base can donate enough to cover both his massive legal bills and a winning presidential campaign? Or is the financial well finally going to run dry? Tell me what you think is the reality here. The blows he feared most, a phrase often used in commentary, are those that expose the reality behind the curtain. The fraud trial was not just about money, it was about the myth. It peeled back the layers of the Trump organization and found that the golden valuations were often inflated. It challenged the central premise of his success. That is a deep wound. As we move forward watching this saga unfold, I encourage you to adopt a skepticism toward the dramatic. When you see a headline screaming, "fatal blow," pause. Ask the questions we asked today. Does this remove him from office? Does this bankrupt him to the point of destitution? Does this legally bar him from the presidency? If the answer is no, then it is not fatal. It is serious. It is consequential. It is historic. But it is not the end. The American experiment is stress testing its institutions. We are watching the judiciary grapple with a unique figure who challenges the norms of business and governance. We are seeing courts willing to impose massive penalties for fraud and willing to strike down executive overreach. This is a sign of a robust system, not a broken one. So, where does this leave us? The landscape of Donald Trump's legal and political future is scarred by these rulings. The New York fraud judgment is a massive crater in his financial topography. The policy blocks are walls erected across his preferred paths, but he is still navigating the terrain. The fatal blow has not landed. What has landed is a heavy burden of accountability that will weigh down his ambitions and resources for the foreseeable future. We are witnessing a slow, complex legal strangulation of his business freedom, coupled with a fierce battle over his political authority. It is a story of attrition, not sudden death. Stay tuned, because as the appeals are filed and the monitors begin their work, the story will evolve. New rulings will come down. Some may favor him, as the immunity ruling did. Some may further constrain him. Our job is not to root for a side, but to understand the mechanics of what is happening. We must care about the truth, the actual, verifiable impact of these decisions, rather than the corporate media spin designed to keep us glued to the screen. I hope this breakdown has provided you with the context and the calm analysis you deserve. Before you go, I have one final question for you. Based on everything we've analyzed today, the money, the bans, the immunity, do you think this is truly a fatal blow, or will he survive this just like he has survived everything else? Leave your verdict in the comments. I read as many as I can. In a world of noise, clarity is the most valuable currency. Thank you for spending your time with me today, and let us continue to watch with clear eyes and open minds as history unfolds before us.